Today we're tackling something that keeps coming up, really. Accountability. Especially, years after a major controversial decision.
Yeah, and the focus today is specific. Former U.S. Attorney Alexander Acosta,
Right.
his recent testimony before Congress, it was all behind closed doors.
And it's all about his handling of the Jeffrey Epstein case back in 2008. A long time ago, but still incredibly relevant.
That plea deal, the one that let Epstein plead to lesser state charges instead of facing federal ones.
Exactly, avoiding those federal sex trafficking charges. This testimony, it's really the first time he's had to publicly, well, sort of publicly defend that decision in this kind of forum.
So, okay, our mission today, for you listening, is to really break down what Acosta actually argued. What was his justification for making that deal 16 years ago?
And critically, how does that justification stack up against the reactions? Because the lawmakers who heard him, well, they had some pretty strong and sometimes conflicting things to say immediately afterwards. It's more than just the political back and forth, isn't it? It feels like a deep dive into legal thinking, risk assessment.
Absolutely. And, consequences. It's a fascinating look at how these really high-stakes legal moments, maybe even failures, get defended years later.
Especially when the outcome is, tragically, very clear now.
Painfully clear.
All right, let's maybe zoom out for a second. 2008 feels like ancient history in some ways. Why is Congress, specifically the House Oversight Committee, digging into this now?
Well, it's not really out of the blue. It's part of this ongoing, pretty relentless effort to understand how Jeffrey Epstein managed to evade federal prosecution for so long.
Even though the FBI was investigating him way back in 2006, right?
Exactly. So Congress is trying to pinpoint where the failures were. Was it institutional?
Hmm.
Was it individual decisions like Acosta's? They want to know how that 2008 plea deal actually happened.
And the goal is presumably to stop something similar happening again.
That's the idea, to understand the breakdown to prevent a repeat.
And the backdrop to all this, the consequences, they're still very raw. We know Epstein died by suicide in jail in 2019, awaiting trial on other charges.
Subsequent state charges, yeah. And Ghislaine Maxwell, often described as his accomplice, is serving, a 20-year sentence now?
Yeah, in Texas.
Yeah.
And the sources we looked at also mention the political dimension, Epstein's connections.
Right, high-profile connections, including, as often noted with former President Donald Trump. That just adds another layer of scrutiny, doesn't it?
It elevates it beyond just a procedural review, for sure. It makes it about whether, status or connections might have played a role way back then.
Exactly. Did any systemic issues or political factors influence that key legal decision in 2008? That's sort of the ghost in the room.
Okay, so scene set. Acosta goes into this closed-door hearing, and almost immediately reports start leaking out, especially from Democrats, and they sound explosive.
Yeah. The Miami Herald, for instance, used words like defiant, unremorseful, even evasive to describe his testimony or his demeanor.
That paints a pretty clear picture of the atmosphere, doesn't it? Sounds like some serious tension.
Definitely. And what's really interesting, based on the reports, is that Acosta apparently didn't back down. He didn't seem to express regret or admit error.
No apology tour, then?
Not at all. Instead, he doubled down. He offered a very specific, almost technical defense for why he made the decision he did back in '08.
Okay, so what was that defense? This is the key piece of information for you listening to grasp from this testimony.
His central argument, the linchpin, really, was about the victims. He asserted, essentially, that the victims' accounts back in 2008 were not strong enough, not credible enough to guarantee a successful federal prosecution.
Wow. Okay, so he's saying he didn't think they could win the case on the federal level.
That seems to be the core of it. He's arguing that federal sex trafficking charges have an incredibly high bar for proof. You need proofs beyond a reasonable doubt.
Which is always tough in these kinds of cases. Extremely tough. Often heavily reliant on victim testimony, which can be complex, traumatic to deliver, maybe incomplete for various reasons. So Acosta's framing seems to be, back then, he weighed the risk. Risk taking a potentially weak federal case to trial, maybe losing entirely. Risking a complete acquittal.
Right. Versus guaranteeing some punishment, some jail time through a state plea deal, even if the charges were less severe.
So he's positioning it as a pragmatic legal calculation, a necessary tactic to avoid the worst-case scenario, Epstein walking free altogether.
Precisely. He seems to be trying to separate the legal strategy from, let's say, a moral judgment. It's about what he thought he could prove in court under federal standards at that specific time.
Professional pragmatism, as you put it. Get some accountability rather than risking none.
That appears to be the argument he's making now, defending that 2008 decision.
But that claim that the victims lacked credibility for a federal case, that's exactly what seems to have ignited the firestorm among the Democrats in that room.
Absolutely. Because it shifts the focus, doesn't it? From a debate about legal tactics or institutional processes
To what sounds like blaming the victims, or at least questioning their accounts as the primary reason for the plea deal.
And you can see why that would be explosive, especially in today's climate, which rightly emphasizes believing victims and seeking justice for them. The lawmaker statements really reflect that visceral reaction.
And we have some direct quotes that really capture that intensity. Representative Maxwell Frost, Democrat from Florida, he didn't mince words.
What did he say?
He said Acosta essentially said he didn't have faith in the victims, their stories, and their ability to tell their own story and their own testimony, which is deeply disturbing to all of us sitting in there.
That's powerful. It directly challenges Acosta's judgment, framing it as dismissing the victims for legal expediency.
Yeah, it puts that cold legal calculus, which Acosta seems to be defending, in direct conflict with the push for victim advocacy.
It's a tough clash of perspectives. And then there was another layer, wasn't there?
Yeah.
About his memory.
Right. Besides the core credibility argument, Representative Suhas Subramanyam, a Democrat from Virginia, highlighted something else. He said Acosta showed a clear lack of remorse, and interestingly, often claimed his memory had faded when they asked him really pointed questions.
The I don't recall defense. That's a classic move in these kinds of hearings, isn't it?
It often comes across as evasive, yeah. Like
Right.
a refusal to fully engage or take responsibility. Stonewalling, some might call it.
Which adds fuel to the fire for those who already see him as defiant. But it wasn't just Democrats, was it? The view wasn't entirely one-sided.
No, and this is where it gets more nuanced, maybe. You have the Oversight Committee Chairman, James Comer, a Republican from Kentucky. His take was quite different.
Okay, how so?
Well, Comer issued a statement suggesting Acosta was actually helpful. He said Acosta cooperated with our questions today and provided information that will help advance our investigation into the federal government's handling of the Epstein and Maxwell cases.
Cooperated? That sounds completely at odds with defiant and evasive and faded memory.
Exactly. It's a real contradiction. How can he be seen as evasive on the core issue, why he made that deal, but also cooperative in advancing the broader investigation?
Maybe the distinction is what he was cooperating on. Perhaps he was willing to share information about, say, systemic problems, or maybe point fingers at procedures or other people involved.
While still fiercely defending his own personal decision-making back in 2008, holding the line on his justification, the victim credibility point, and maybe using the faded memory for questions specifically about his own culpability.
That could be it. He might have provided useful context about the whole system around the Epstein investigation memos, other players' internal discussions, things that help Comer's committee build their bigger picture of federal mishandling.
While drawing a protective line around his own actions and rationale, it's strategically interesting, if that's the case.
It certainly suggests a complex performance under pressure.
And this whole contrast, this evasive but cooperative situation, leads us right to the committee's promise about transparency.
Yes, the transcript.
Exactly. Chairman Comer specifically said that the full transcript of Acosta's closed-door interview will be released eventually.
Which is crucial, really. It moves beyond the he said, she said, based on immediate reactions from lawmakers with different perspectives.
It allows everyone, allows you, the public, to eventually read the exact questions and the exact answers. See the context for yourself.
See where he claimed his memory failed. See precisely how he phrased the defense about victim credibility. It's the key accountability measure here, isn't it? Full visibility to hopefully learn lessons and prevent future failures.
Right. So if we pull this all together for you, what's the main takeaway from this deep dive?
Well, I think the core tension is crystal clear. You've got Acosta's defense, a pragmatic, if difficult, legal choice made in 2008 based on his assessment of victim credibility for a tough federal case. And slammed right up against that is the condemnation from lawmakers who heard defiance, evasiveness, lack of remorse, and an unacceptable dismissal of victim stories. And the value for you, listening, is seeing how legal accountability plays out years later. It becomes this battleground where concepts like memory, credibility, the burden of proof, they all become strategic tools.
Tools for defense or weapons for condemnation, depending on your perspective.
Exactly. It's not just about what happened back then, but how it's framed, justified and attacked under intense scrutiny today.
And right now, much of that justification, that specific exchange, is still wrapped in the ambiguity of that closed-door setting. We only have the conflicting reports.
Which brings us to a final thought, maybe a question to leave you with, related to that promised transparency.
Go on.
If Acosta was described so differently evasive by some, cooperative by another, what will that transcript actually reveal about the faded memory claims?
Yeah, will we see genuine lapses, or will it look more like strategic silence on the really pointed questions about his own judgment?
What nuance will emerge about how these high-level, high-consequence legal decisions are defended when the pressure is really on, years later?
That transcript release, whenever it comes, will certainly be a key moment in understanding this whole saga of accountability and legal defense.
Definitely something to watch for.
Indeed. Well, thank you for helping us unpack the sources today.
My pleasure.
And thank you for joining us on the Deep Dive. We'll see you next time.